Welcome to Channel 17, the Town of Colonie Government Channel.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our criminal justice system, our legal system, and how they intersect with the citizens of the town of Colonie. Today, we are truly fortunate to have an internationally renowned law professor who has taken the time to join us and discuss a variety of legal issues currently involving New York State and even the federal government. And I hope you'll join me in welcoming law professor Michael J. Hutter. How are you? And thank you for joining us today.
Thank you for having me, Peter. It's a real pleasure.
Well, we're thrilled, and I have to say that when I was able to convince you to join us today, and because your schedule is so busy, and I said if you could just give me a small bio that I could consider revealing to all of the citizens here in the town of Colonie, you did just that, one or two paragraphs, and I can tell you that is the most modest and humble approach to a resume that I've ever seen. Because actually, if any of our citizens go online and merely Google Michael J. Hutter, they will come to know quickly what I've known for many, many years, even as a student at Albany Law School, while you were a professor there, that you are internationally known and you continue to play a prominent role in the development and the maturity of law here in the state of New York on so many different levels. And I just think, just to give an overview of some of the topics that you've written on and also teach on, and of course you're currently teaching New York practice and evidence at Albany Law School, but you've been called upon to write a variety of papers and treatises on a variety of topics, including the admissibility of employee statements, no-fault insurance update, labor law, remedies in trade secret cases. It never ends. And in fact, when I've told attorneys that you would be our guest today, they were all appealing to the Bar Association to make sure that this counted as CLE credit, because you routinely teach other attorneys the practice of law, and we're so lucky in that way. And you have been involved in so many cases that have reached our highest court. And in fact, our citizens should know that you, as a young attorney, clerked for Judge Matthew Jason, Court of Appeal judge.
Long time ago, from 39 years ago.
How did that happen? How did you get involved with the Court of Appeals in the first instance?
In law school, as you know, many of the cases in the case books are Court of Appeals cases. And so during law school, you're reading decisions by Cardozo, the great names from the history of the New York court system. And at that time, and it's up there, the Court of Appeals was considered one of the top state courts. And I kind of aspired to it. And my dean at the time was Father Drinan, who had developed a very good relationship with several of the Court of Appeals judges, including Judge Jason. And he had said, he asked me what I was doing, I said, well, I'm going to return to my native New York. I'm not sure what exactly I'm going to do. He said, well, consider the Court of Appeals. And I said, you're kidding me. That's too far. He said, no, try it. And so I set me up with an interview with Judge Jason, who the two of them got along fabulously. And I flew out to Buffalo. I actually flew out here to Albany on a Mohawk flight from Boston to Albany, and had a great time with him, and got back 2 days later and had the offer from him. And it was just a fabulous experience. He kept his chambers in Buffalo, so we lived in Buffalo for years, and then we'd commute back here every 3 weeks for the sessions. But it was just a wonderful experience sitting there, seeing these decisions, how they evolve, and sitting back in history and be able to say, I was writing a draft of an opinion sitting at Cardozo's desk. So the history is just remarkable.
Well, and it's interesting for me, too, your relationship with Boston College, and you graduated from Boston College Law School, and while I was an undergrad there, of course, Father Drinan was a very large player in and around the legal community, and also became a congressman, as I recall, and had quite an impact on the Boston College community, and I think it's great that he was able to also provide some wisdom and advice on you coming into the Court of Appeals. And you've never left, actually, as a result. You are called upon.
It's hard to.
You've been called upon numerous times. In fact, you've argued over 350 appellate cases, many of them before the Court of Appeals, on a variety of different issues. And you've also most recently had involvement in the Skelos versus Patterson matter concerning Lieutenant Governor. And of course, that's of major interest to our citizens here in Colonie. We've read about it, we've heard about it, and I believe ultimately the Court of Appeals has recently ruled on that matter of the succession for gubernatorial and succession, and
I might add, went contrary to the position I advocated.
Well, that's okay. They've certainly the record benefited by your brief that you submitted. Tell us what the Court of Appeals eventually concluded in this matter.
Well, a little background. It's interesting. The way the Constitution is written is that the Lieutenant Governor really has very little power. All the governor is charged with is presiding over the Senate, and essentially that means being a parliamentarian, controlling debate, and then the lieutenant governor can do what's called cast a casting vote, which allows the lieutenant governor to decide matters in which the members are tied on. There's even split, others provided it doesn't involve a bill. So they can talk. He can cast a vote with respect to budget things, appointments, but nothing real legislative. And over the last 40, 50 years, there have been very few times where the lieutenant governor has ever done that. And then the third thing that he stands by or she stands by is to become governor when the governor steps down. Other than that, there's nothing. Now, the legislature through the years is giving the lieutenant governor some things, the lieutenant governor, ex officio member of the Cornell trustees, a member of the advisory board of county jails, ministerial things that really are nothing, but lieutenant governor has nothing. And then the Constitution with that in mind says when the governor steps down or is a vacancy, lieutenant governor shall become the governor. And then it says that in situations where there's a vacancy in the lieutenant governorship, the powers of that office are vested in the temporary president of the Senate. Now, the powers simply, again, are very limited. And it says nothing more. And it appeared that what the framers of the Constitution did, starting back in 1777, with respect to then the amendments in 1937 Constitutional Convention, was to basically leave that position vacant when it's a vacancy. In that respect, the lieutenant governor is to be an elected position, elected together with the governor on a joint ticket. Prior to 1944, the lieutenant governor would run separately, and theoretically you could have a Republican governor and a Democratic lieutenant governor, or vice versa.
That's right.
They said, no, you run together. And while in 1943, the Court of Appeals said that when Governor Dewey's lieutenant governor, actually he was Henry Wallace from Schenectady, died in office, had a sudden heart attack. There was a vacancy, and the question was, well, how do we fill it? Everyone agreed there's no appointing power. Dewey was very concerned because at that point he wanted to run for president. And he knew that, but he did not want to step down. He did not want to have the possibility of a Democrat becoming governor. So he decided he wasn't going to do anything. The Democrats said, no, we think that something be done. And so they said that an election is necessary. And the Court of Appeals, after some litigation, said the way the Constitution was written back then, you could fill it by an election. Fortunately, a Republican won the special election, so Dewey was saved, but Dewey then rammed home an amendment that prevented that. So for years, it was the only way you become lieutenant governor is through an election. Now, yes, if the lieutenant governor takes office early on in the tenure of a governorship because the governor steps down, that can mean it's 3 years vacancy. But big deal. There's really nothing that's untoward there. Now, you might say that, well, what happens is the lieutenant governor becomes governor, he then dies or leaves office. Well, the succession then would go to the temporary president of the Senate.
Right.
And then if the temporary president of the Senate, then to the assembly leader. So there are some succession there. So what happened then with in this past year with respect to all the problems that the state Senate was having, Governor Patterson thought that when there was a split, no one seemed to know what was going on. Maybe we need a lieutenant governor now to cast that vote when it was evenly split. So he decided that he did believe he had the appointive power. Our view was, again, that the Constitution did not permit it. And the basic reason was in the way the Constitution was set up. What Governor Patterson is claiming, and now the Court of Appeals upheld this, the governor alone can designate who is to be his or her successor, meaning they have the right to name the next governor. I call this the divine right of succession, allowing an executive leader now to say, Peter, how'd you like to become governor one day? Or, as it came up at oral argument, this would allow the governor to appoint Bernie Madoff, son of Sam, David Berkowitz. All the requirements are to be 30 years old. They certainly meet that. And with no confirmation. Now, the claim is, well, they would never, ever do that, too much politics. But again, as we saw with Illinois, you step down then. You appoint someone, then you step down. And they don't take the heat. Just the potential that we would have an unelected person sitting as governor is something that really is contrary to what the framers wanted. We wanted someone who'd been vetted by the people. Now, you're vetted by the people if you're a lieutenant governor, because at least you're running for governor with someone.
That's right.
You survived a primary fight. Right. So there's a thing there. But then with the lieutenant governor goes the governor and then has the ability to appoint someone who did not go through that is, we believed, and myself and the others who made the amicus, two very distinguished political science professors, Jerry Benjamin from New Paltz, Peter Galey from Canisius, and then Stan Lundeen, the former lieutenant governor under Governor Cuomo. Our view was that it's got to be filled at an election, at the next election. It lays vacant. And now we have the possible spectacle of a non-elected person, David Ravitch. I don't know much about him. He seems to be a very capable person. He can possibly succeed Cuomo, Governor Patterson.
Right.
And the people now are saying he can step down now, so David Ravitch can become. David Ravitch has never been vetted by the people. He never went through any confirmation. At least people say, well, gee, how about temporary president of the Senate? Well, the temporary president of the Senate at least has been vetted by his district and then vetted by his own party to become that. So there is some input by the state of New York, the populace. You don't have that with David Ravitch. And does that mean that he can't command respect of the people? Well, it's possible.
Right.
And again, yes, he appointed David Ravitch, but he could appoint Peter Crummey. So there's a potential. I know you had on a guest a couple of shows ago, Victoria Graffio.
That's
from the Court
correct.
of Appeals. Mm-hmm. And she made a very apt observation during oral argument. This opens up a real problem with partisan politics, this appointive process. And I think she hit the nail right on the head. Yes, looks good with Richard Ravitch. What's next? And we could see a succession now of people sitting in the governor's chair who have never been elected or vetted by the people.
And who then have the power, pursuant to the recent decision by the Court of Appeals, to appoint a new lieutenant governor.
Yes.
So you could have a governor and a lieutenant governor who were both got to those chairs by appointment.
Exactly. And again, who was Richard Ravitch thinking about?
Right.
And the Senate and the Assembly have no check on that. And it's interesting with respect to the section of law that the Court of Appeals relied upon talks about vacancies with the Attorney General and the comptroller. Now, those provisions of law say specifically, unlike with respect to lieutenant governor, that the successor to a vacancy in the attorney general's position and in the comptroller, the entire legislator. So they were not going to allow, and the governor now to say appoint or anything, the entire majority vote of the entire legislature. So it's clear that I think here, and this is where I think the decision in the Court of Appeals is somewhat troubling. They really ignored that broader part of the history of the Constitution and what the framers clearly intended, instead focusing on some language that now 9 judges have viewed it, actually 10 judges have viewed it, and they've all come out differently on the language.
And there were dissenting opinions filed as well
Yes.
by the court, but it's now the definitive rule in the state of New York in that way. But
Until legislation. Now, the way the decision was written does allow the legislature to change it. I haven't seen any bills, but I know that in the aftermath, several assemblymen had voted saying, I don't think we want to give the governor this full power. So you may see some effort, I don't think in a special session, but perhaps next year, putting in a bill to at least give confirmatory review by the Senate, or maybe even by the entire legislature, to whoever the governor appoints.
Now, our federal system, pursuant to the 26th Amendment, attempts to address the succession for president. Is that correct?
Right.
And how does that work in the federal system?
In the federal system, it clearly goes to the vice president. And when the vice president now, there is a vacancy, that it just remains vacant. In the event then that the vice president were to pass away, having assumed the presidency, there's a succession. I think it goes to the attorney general, it goes to the Speaker of the House, and then the Senate Majority Leader, then to the Attorney General. There's a very distinct position there. But again, even in the Constitution, clear, there's no way in the world we want a person who has not been vetted by the voters to ever get close to the presidency. So it's very carefully guarded. Now, when the position of lieutenant governor then opened up in the aftermath of the 26th Amendment, that's when Rockefeller became vice president. Ford takes over the presidency when Nixon resigns. Then there was he appointed Rockefeller. That had to be approved by Congress, and we don't have that. So at least there, when Congress is vetting, that's the equivalent of a voting, and we don't even have that in New York now.
Professor Hutter, you've shared your talents far and wide throughout the state of New York, and currently you are a commissioner on the New York State Law Revision Commission, which actually plays an integral role in the development of law in the state of New York. And some years ago, you actually served as the executive director of this same commission. Tell us what types of things are on the burner now, or some of the highlights that the commission has set forth recently.
Well, I think the first thing that we are very proud of that we did is we've been worked on and it was passed last year, a power of attorney bill that revised the way powers of attorneys are visited upon people, how the powers can be exercised, because there was so much fraud going on, where someone would come forward, I have this power of attorney from a very wealthy woman, the estates are looted, there's all sorts of fraud. So we cracked down on that. We put together a bill, we worked closely with the DA's Association, the various bar associations to try to ensure powers of attorney, as you know, Peter, serve a very valuable purpose.
Yes, they do.
But they're susceptible to abuse. So we think we've curbed a lot of the abuse potential. And now we're looking at, and we just issued a report last week. 2 years ago, we were asked by the legislature to look at the operations of the State Liquor Authority and the ABC law because of various complaints. We did that, and we held a lot of public hearings. We issued the initial report. Our final report is due at the end of the year, December of 2009. We issued a preliminary report where we simply addressed the administration of the SLA presently, or at least because there's been a new SLA point, I'll get to that in a minute, but how it's been operating over the last 2 years. And we came with the conclusion it was an abysmal failure. It was absolute disgraceful. Lack of leadership, and a lot of that can be attributed to lack of financial means given. The state liquor authority, by their fees and dues and everything else, registration fees, brings into the state some $57 million. Only about 20 million of that is returned to them to do the operations. The other 30 million goes into the public fisc, into the general treasury. And Department of Budget kept on nickel and diming, so that you didn't have enough examiners of license applications. You had license applications being backed up for 7, 8, 9 months. And to be able to go on an application, you had to have a lease. So people have now spending thousands of dollars on a lease they can't use while this is sitting there. Then we're finding out, and the DA down in Manhattan found out, well, we see what happened. People then were bribing the examiners. We want to get first. They had no processing. They had no computer equipment. They had lack of examiners. The Division of Budget kept on saying, well, you can do this and get away. Division of Budget was micromanaging SLA, and the SLA really didn't have the ability to go back and counter that. So it was just absolute disaster. Then they had all these outmoded laws that they were trying to enforce, where a winery can have a wine tasting, sell their wines to family members who visit the winery, whether it's in Finger Lakes or wherever. And then when they had their children there and the children get thirsty, the children say, I like a bottle of water.
Sure.
They can't sell bottles of water. Why? Because SLA won't allow it. Why? Because the law says that, or their interpretation of it. So we came out with a report very critical of the SLA. Governor Patterson, to his credit, and I think the legislature's credit in confirming, did appoint a new head of the SLA, a former assistant attorney general, very aggressive in overseeing some of the criminal investigations of the liquor industry a couple of years ago. Put him in. He's got a new team. He agrees with, I think, almost every one of our assessments he's trying to do. We're now seeing money starting to flow into the SLA. And then our next step will be to recommend some modernization of these laws. The ABC laws stem from Prohibition. They haven't been changed since then.
Well, they're lucky to have your overview and oversight on the development of bringing this particular body of legislation into the 21st century. There's so many other issues that come to mind in considering the evolution of our laws and how they're interpreted. And we know that in the federal system, our judiciary is generally and typically appointed. And there are some states, possibly even Massachusetts, seems to track more of a federal type of appointment system. But here in New York, I believe for the most part, our Court of Appeals, since maybe the mid-'70s, has been an appointed process, but they too were once elected themselves. But the balance of our judges, including our Supreme Court judges with 14-year terms, and our county court judges, and our town, village, and city judges, all are elected. Do you have any position on whether you think that the judiciary would benefit by having it all elected, or all appointed, or some here, some there?
I think the way the system is working now, both the state Supreme Court and the county court, family court, surrogate court, is one that now is starting to break down, because qualified people do not have the opportunity to be considered. And the reason is that politics controls everything. And interestingly, 2 years ago, this was a finding of a federal district court judge who struck down the system for electing state Supreme Court judges. Totally party controlled, no primaries. You have that convention, and it's basically controlled by the political bosses. You had to really become a member of the politics to get in it. That was struck down. The Supreme Court said, no, that's really, the state should be able to do what they want. So we're back to square one. But in order to become a state Supreme Court judge, you really have to, you just can't present yourself with a great resume and say, okay, I want to go in. Really, most of the counties are all looking at, what have you done for the party? Sometimes you'll get some very, very good judges. We have some great judges who went through that. But a lot of people who are maybe the equivalent are prevented from getting into it. People whose jobs now are DAs, public defenders, general counsel for state agencies, terrific lawyers. They really can't get involved in politics because of their positions, and they don't get into the system, and they're not really being considered for it. And I think there in New York, where we have some absolutely terrific lawyers, the vast majority of them are incapable of even getting to be considered for a judgeship. There's got to be a better system. Now, the appointive system, it's working well with the Court of Appeals. In that situation, you have an independent commission that does the screening. Then they recommend names to the governor. The governor must choose from that. It's much better than simply allowing the governor to pick whoever he or she wants. That Court of Appeals system, I think, certainly can be replicated on the lower level of state Supreme Court with commissions now maybe geared to the various communities and receptive to that. But I think that is something New York has to look at. I'm fearful that as things drag on, the quality of the judiciary is going to get worse and worse, especially when you tie it together now with the compensation lag. Lawyers who are really good, they're making a lot of good money, even counsels in agencies, the DAs, they're not making the money that judges are making now, but they may say it's not worth it. So unless something is done to make it more attractive, but even increasing the salaries is not going to do much unless you open up the system and get more people, allowing them to be considered.
Professor Hutter, you've commented on and provided legal opinions on so many issues, and at the outset I did acknowledge that you're internationally renowned on so many issues, and I note that not that long ago you spoke and presented a paper internationally concerning the prosecution of public officials and for corruption. And of course, all of us that live in the Beltway often hear of such prosecutions here and about rising out of the Capitol and other political subdivisions. And I note that there's a paper that you had provided and in that way. And that was an international paper, wasn't it?
Yes, I had the pleasure, and I was very honored to be asked, along with 3 other lawyers here in Albany area, David Homer, who's the U.S. Magistrate Judge, Henry Greenberg, who's now counsel to Governor Cuomo. Both Dave and Hank were former federal prosecutors. And then Bill Dreyer, a very renowned defense attorney who's defended a lot of these political corruption cases. Hank and Dave had prosecuted them. And we were asked by the American Bar Association that have a special group that provides legal advice and help to emerging nations or countries that want to develop a system to combat political corruption. So we were asked to go for a week to Thailand and meet with the judges out there, make our presentations, talk with them about what we're doing in the United States, not telling them that this is the way to do it and you people don't know what you're doing, just giving them the exposure. And it was interesting, the way it started out is that we're not coming in there as a white knight on a horse saying we have no corruption because we ferreted it out. The week before, you had the governor of Connecticut being indicted, and then the governor, even before Rod Blavovich, the governor of Illinois being indicted. So I said, it's not going to solve anything. We have our problems, but this is a start. This is something you can consider. And it was very well received. We had some real good discussions with that. We then understood about 2 years ago, they then went through a political upheaval where they threw out their prime minister for some political favoritism and things. I don't think he was ever investigated, but it was a fascinating thing. And I think the American Bar Association does good in that sharing the knowledge of lawyers and judges and putting together a cross-section just to say, not to preach to foreign countries, but say, consider this.
Right.
They set up systems now with respect to, I think they did a session in Mongolia, Vietnam, they were looking, Cambodia looking at, obviously some dictatorships, the country formerly known as Burma, now Myanmar, I think that's how you pronounce it, wouldn't let the ABA near it. But this is something that was very nice. And we're trying to arrange, we have been trying to arrange getting the Thailand judges to come to New York and spend some time in the Capital District.
Well, you've shared so much of your talent and love of the law throughout, and I know you've chaired a variety of committees on behalf of the American Bar Association, the New York State Bar Association, and currently serve as a director of the Albany County Bar Association as well. And of course, all of us want to know what elixir you're using to be able to continue to do all of these things, all in support of law and justice. It's a fabulous work in progress for all of us to see and benefit by. And how's Albany Law School these days? What's the latest?
Oh, it's great. Things are going good. The economy obviously is bad. Our students are still getting jobs.
Good.
Most of our kids, as long as you stay away from the major firms with their upheavals. If you go into a mid-sized firm, whether in New York or upstate, these firms are hiring, and our students are going there and they're getting hired. I think we provide our students with a terrific education, and I don't see any reason why that's not going to continue through the years.
Well, we're so lucky to be able to have you there as well, and your commitment to our area. And currently you're serving, I believe, as secretary to the board of the Albany County Bar Association. And I believe their work has been well received by the citizens as well as the bar. I think that they have well over 1,100 members now. And with people like Michael Hutter as part of the board of directors, I think that it gains the distinction and the level of respect for all of the good work.
I must say, and it's not going back and forth, but you've contributed a lot to us, your position as a director on the board as well.
Well, I'm very fortunate to look to you as a leader in the field of law, and so does everybody else. And I know that the citizens of the town of Colonie feel that way as well, and we're very lucky to have had you join us for just a few moments of your very valuable time so that the citizens can get some exposure to some significant court cases.
My pleasure, Peter, really.
That are evolving with you involved right here in Albany, New York, through the Court of Appeals and a variety of other courts as well. And thank you, Michael Hutter, for joining us today.
Thank you for having me.
I'm Judge Peter Crummey, and thank you for joining me on Benchmark.